So today we're going to talk about the most common forms of medical malpractice in Kentucky. This is probably generally true in almost every state. Very common forms of malpractice and what you need to know if you or a loved one has been injured by malpractice. The first thing you need to know is the legal duty that healthcare providers owe to patients. They owe the duty of reasonable care. And medical malpractice happens when there is a breach of that standard of care, when providers deviate from the professionally accepted standard or practice. And then you have to prove that that specific breach of the standard of care caused you harm that would not have otherwise occurred. This is the element of causation. And you have to prove all of these things with expert proof. In other words, you need a doctor or a healthcare provider like the one at issue in the case to prove all of these elements. Critically, there are deadlines in Kentucky, which has one of the shortest statutes of limitations for medical malpractice in the entire country. It is 1 year from the date of the incident or discovery of the incident. And you also have to file what's called a certificate of merit even before you file your lawsuit. So you really need time to not only bring your case, but to find an expert who will support your case before you can even file the case in the court system. So today we're going to talk about 5 different categories of malpractice. We'll talk about misdiagnosis or delayed diagnosis, surgical errors or surgical complications, medication errors, birth injuries, and nursing home abuse and neglect. Misdiagnosis or delayed diagnosis is very common, usually in an ER setting, and although not always. And we're talking about physicians missing, for example, cancer, heart attacks, strokes, other serious conditions, appendicitis, testicular torsion. We've handled all these types of cases. And usually what happens here with misdiagnosis is the failure to order the correct test. And the way that this happens is that the provider should do a thorough workup of the patient history, complete physical exam, including abdominal exam that's often missed, for example, in appendicitis cases, appropriate diagnostic testing, whether that's an ultrasound, an EKG, whatever it is that should have been ordered that wasn't, specialist consultation. Maybe they needed to refer this out to a specialist like a cardiologist or a urologist or whoever, and they don't do that. So all these sorts of things can be misdiagnosis. So common failures here include the test that's not ordered, the patient's symptom that is dismissed, rushing the discharge, no follow-up appointment scheduled, failing to review the test results. Sometimes you see that where the test results say something that should have resulted in a follow-up call to the patient, like, hey, you need to schedule this other appointment or you need to come back to the emergency room right now, and that is just not done. So these are common examples of misdiagnosis and delayed diagnosis. So to illustrate this with a real fact pattern, let's say there's a 52-year-old Kentucky resident presents to the ER with chest pain. The doctors and the nurses dismiss this as indigestion. They don't do the right workup. They don't order an EKG. They send the patient home. That night, patient suffers a fatal heart attack. Then the question would be, would a reasonably prudent ER doctor have done anything differently? And basically on that fact pattern, the answer should be yes, but that's just an illustration. Second category of medical malpractice is surgical errors. And what we're looking for here is that they verify that it's the correct patient they're supposed to be operating on, verify that it's the correct site, not the wrong leg, for example. There's literally been a case of amputating the wrong leg because they forgot, someone put the marking on the wrong place. Sounds unbelievable, but it's true. Following the right protocols, instrument count, and this is a big one in terms of leaving objects behind, what we call foreign object cases. We've handled several of these where, for example, a sponge is left behind. It shouldn't be. Or we had one where an actual hook was left in someone's heart during heart surgery. So these are kinds of surgical error malpractice cases. And the injuries in a case like that would be not simply that the sponge is retained, but it might lead to infection, further hospitalization, inpatient hospitalization, so expensive medical bills, follow-up surgery to repair and remove that, take the sponge out or the hook or whatever it is. And if there are any complications from the follow-up surgery that they had to have because the sponge was left behind, that's all part of that case. So, These can be kind of complicated in terms of the fact pattern, but really the act of malpractice is pretty simple. It's leaving an object behind that shouldn't be there. The third category is medication and prescription errors. You see a lot of variation in this category. It can be sometimes the entirely wrong drug was prescribed. We had a case where a young woman went to get a birth control medication from her primary care provider, and the primary care provider had mistakenly ordered an antihistamine, an allergy medicine, instead. It had a very similar name. So this young woman ends up not getting her birth control and getting pregnant. So that's an example of, a medication error that shouldn't have happened. Or another common one is the incorrect dosage. We had a case where the providers calculated the patient weight incorrectly because of a mess up between the metric system and the US system in terms of weight. They effectively severely overdosed this patient with a very strong anti-seizure medication. So that's an example. Allergies not being verified, prescribing a drug that a patient could be allergic to. And then pharmacies just making mistakes in terms of filling the wrong drug. And if someone, for example, needs a drug to stay alive, and then the pharmacy messes up and gives them someone else's medication or the wrong medication, and they don't get those drugs that they needed, and then something terrible happens, that's an example of a case we've handled against the pharmacy. So as an example, what if a pharmacy makes a mistake and fills a prescription 10 times the intended dose, and then the patient suffers organ failure? Would that be a malpractice case? Yes, I think so. So that's just an example of a medication error or a pharmacy error. The fourth kind of injury we're going to talk about can be very significant and complicated. That is birth injuries and obstetric care injuries, OB-GYN malpractice. So in a normal labor situation, the fetal heart rate monitoring will tell you that the baby is healthy and the signs are reassuring. But if something goes wrong and those heart rate monitors detect distress, there's a critical window where doctors and nurses are supposed to intervene. So a major focus in these cases is the failure to rush a C-section delivery or to provide oxygen therapy and to implement these sorts of measures. And what happens is there's usually a deprivation of oxygen to the baby, which causes permanent brain injury for the rest of that child's life. So common birth injuries include cerebral palsy, brachial plexus injuries, it's like a bad shoulder injury, also called shoulder dystocia, hypoxic ischemic encephalopathy, also called HIE, a major injury, very common, sadly, in these sorts of birth malpractice cases, and maternal hemorrhaging or injuries to the mother from lack of management during the delivery. So the usual fact pattern in a case like this involves a prolonged period of labor and delivery and a failure to order a timely C-section or some sort of intervention to quicken the process of labor and to make sure that that baby is not suffering from a lack of oxygen. Birth injury cases can be extremely expensive to litigate because of all the different types of experts involved. At the same token, they can be some of the most significant malpractice recoveries because of all the care that children will need and all of the future economic costs associated with that, to say nothing of the pain and suffering. But usually children who have been harmed in this way will require future medical care in the millions of dollars over the course of their lives. So that's why they can be such significant cases. Okay, nursing home and long-term care negligence. Unfortunately, this is an area where there is sometimes intentional misconduct and abuse. So you might see unexplained injuries that don't make a lot of sense, like cuts and bruises and fractures that shouldn't be in places where they are. Very common one is pressure sores or bed sores or pressure ulcers. This is essentially negligence almost by definition, because what happens here is staffing gets short and the patient is not turned, is not moved, and as a result, these very horrific injuries can occur, these pressure ulcers. And they usually, almost by definition, mean that the patient was neglected. And these can be very significant cases in situations where it's really a larger staffing issue, a corporate greed issue, where for-profit nursing homes know that they don't have adequate staffing, but they're running the operation in a way to maximize profits. So they're not really putting patient care first, they're putting profits first, and juries will pop them for big numbers if that's the factual situation in the case. And there could be all other manner of cases in these nursing home situations: dehydration, malnutrition, unanswered calls, failure to follow fall protocols, or a patient falls down and is not assisted for several hours, something like this. There can be a lot of different areas in the nursing home space for malpractice claims. And a key way to prove this sort of staffing failure or malpractice in treating nursing home patients is through the evidence, the staffing logs, the medical records, these sorts of things, to show that checks were not done, patient was not turned, patient was not checked on, fall protocols were not initiated, all of these sorts of things that can help prove the case. Okay, let's talk about what medical malpractice is not. And this is a conversation we have a lot, right? So just because something bad happened does not mean that it's medical malpractice. So as an example, known medical risks. When we have to turn potential clients away in malpractice cases, one of the big reasons for this is that what happened is just a rare, unfortunate, known risk of the procedure. And usually in the paperwork, when you agree to a procedure, it'll say, here are the risks. And when one of those things happens, it doesn't necessarily mean that there was malpractice. There can still be malpractice in other ways. For example, if they don't inform you of the risks, or provide discharge paperwork so that you knew you were experiencing that outcome, or if they don't order proper follow-up in the aftermath. For example, if you develop an infection and they don't properly treat that, but infection was a known risk of a procedure, as an example. But this is a big one where we have to turn cases away a lot by saying, well, unfortunately, this was a risk of the procedure. The next one is acceptable judgment calls, right? Reasonable professionals can disagree on what the best course is or what the right action is. Medical malpractice really only happens when you have what I would call an F, right? Maybe the A+ doctor would do one thing and the B- doctor would do another thing, but what you can't have is the F, right? The below the standard of care choice that no reasonable doctor would do. But if you get into a debate of, well, you could have ordered this test, but this other doctor over here says you didn't really have to, then you might lose the case because you don't prove it was an F, it was below the standard of care. So anytime you get into a real close call about judgment, usually a pretty good sign that the case is not that strong and that you might not be talking about malpractice, right? It may be that you didn't get the best medical care under the sun, but that doesn't mean it's malpractice if a reasonable doctor could have chosen some other course of action. So what we're really looking for in malpractice cases is preventable errors. Deviations from the standard of care that no reasonable provider would have chosen. So if you suspect that you or a loved one have been the victim of malpractice in Kentucky, what should you do? Okay, well, first of all, recognize the signs. If you have unexplained complications or preventable errors or things that just shouldn't happen, we sometimes call these never events, just results that kind of boggle the mind and should not occur. That's a pretty good sign that you might have a malpractice case. So the first thing you're going to want to do is to get all of the relevant medical records. We really won't be able to tell you if you have a viable malpractice case until we see those. And you can always get those much more quickly and more cheaply yourself rather than having an attorney do it. Then pursue a legal review. I'll leave a link in the description, if you wanted to contact us, but have a lawyer look at those closely. Make sure you choose a lawyer that actually does medical malpractice work, not just general personal injury, because it really is, a very detailed process and you want people with experience in this area. I mentioned earlier, you will need an expert opinion supporting your case before you even file it. In Kentucky, you have to have what's called a certificate of merit, and then you can file the claim in the court of law. Remember, you've only got 1 year to do that. And of course, also be aware that malpractice attorneys like us will charge a contingency fee, which means you don't owe anything up front. You only owe something if you get paid at the end. And I'll link to a video explaining personal injury lawyer fees in more detail if you have any questions or confusion about that. But just to reiterate, you have only 1 year in the Commonwealth of Kentucky to figure this out, so do not delay. I'll leave a link in the description if you want to contact us. Here's the link to that video explaining personal injury contingency fees. Thanks for watching.